decision, admin body decision was final or it's not a final? It's a premature decision or it's a mature decision?
Premature.
Why?
Premature.
Because it is a PD or
Final,
okay.
final hearing.
Sorry?
Final hearing is still pending.
Final hearing is still pending. Hearing was already set up. Where is written hearing is set up? So in first paragraph, I made an investigation. After the investigation, I recommend hearing should be set up. Now, did they set up? Read second paragraph. Whether they have set up the hearing or not. Read second paragraph.
Full paragraph.
Yes.
In January of 2006, the chair of the discipline board sends a complaint of professional misconduct against Gerard Demuth to the society's investigators, and following an investigation, the matter is sent on to the society's prosecutor to set up a hearing.
I recommend to set up the hearing. My job is done.
At this point, as provided for in the rules, the board stages a pre-hearing conference. At that conference, Demuth is represented by Harvey Kyoto, a former dentist who has, without protest from the board, acted for a number of years as an advocate for dentists charged with professional misconduct, including Demuth himself on one prior occasion. At the pre-hearing conference, however, the chair tells Demuth and Kyoto that henceforth it will allow only lawyers to act as counsel at hearings.
At hearing, it means hearing is already set up. Expression. It means hearing is already set up. If hearing was not set up, how I'm gonna say you? It means hearing is already set up and you did not avail that hearing. Make sense? No, seriously, make sense or no?
But is it the case that he is barred from hearing because they have not recommended that only lawyers could put that case representing the dentist?
Okay, no. The point to be noted. Okay, every step has an independent step. Okay, I need your eye contact. In my class, I need your eye contact. There is no right and wrong. In administrative law, there is no right and wrong. For example, you are fighting with this nice girl, although you will not gonna fight. Okay, and you are fighting with nice man, although you will not. But according to my opinion, girls are. Husband and wife, you know, so I'm biased. See, this is a bias. Close mind. See, close mind. This issue you will see in an exam. You will see exact close mind. Exactly. Close mind is a very important topic. If you are fail in administrative law, read your failure report, close mind versus reasonable apprehension of bias. Anyway, you both are fighting. Okay, you both are fighting. Okay, you are, okay, you know what? At this point, you are 100% right. At this point, doesn't mean you are 100% right. At this point, you are right. One step is done. You know, at this point, you are 50% right. At this point, you are 100% wrong. At this point, you are 50% right. At this point, you are 100% right. You are, see, step by step. Every step has independent value. Every step has, do not correlate with every step. You got it? Have you exhausted? Okay. Room number 1, step number 5. Whether decision, don't worry about decision. Whether that decision, whether, okay, premature or mature. Did you avail hearing or not?
Yes.
Did you avail hearing?
No, like hearing is set up, but it's premature.
Decision is premature. You got it? Don't look at. You got it? If you are fail in NCA. Excuse me. Hello? Okay. Point to be noted. Do not worry. Okay. I'm a commissioner. My decision is final. Don't worry about my decision. You will not gonna get right to counsel. Don't worry about that decision. Whether did you avail final decision? Final decision would be always would be if right to in NCA, if right of appeal is available, that would be a final decision. Doesn't matter if you, okay, you are fail in NCA, you got 0 out of 100. You got 0 out of 100. Doesn't matter. Did you avail right of appeal? If yes, this is a final decision. If not, this is not a final decision. You know what, ma'am? I'm an examiner. I'm a paper checker. Although I'm not, I'm just giving you example. Okay, you know what? You got 0 out of 100. Mark my words, you will not gonna pass 100%. 100%. According to your opinion, you will be pass. According to my opinion, doesn't matter. You are 100% fail. Doesn't matter. Still, right of appeal is available. You have to go to the right of appeal. Whatever I'm gonna say, if okay, one example in the pre-hearing, issue, you know what? In the hearing, we're gonna slap 5 times to your face. We're gonna slap to your face 5 times. Still, you have to avail that final decision. Get 5 slap, then go to the judicial review. You got it? You will not gonna get right to counsel in the hearing. Right to cross. Judge would be biased. In the pre-hearing, you know what? Decision maker would be biased. He is against the Indian people. I'm telling you, he is against the Indian people. Okay? He is against the ladies. He is a racist guy. He will not gonna provide you right to counsel, right to cross-examine. But hearing is set up. Based on this point, still you have to avail hearing. If you will not gonna avail that hearing, gonna go to the court gonna say doesn't matter. In the hearing, you will not gonna get anything, but go back, avail the hearing, then come back. This is called final decision, right? Make sense? Make sense?
Yes.
Happy or not happy?
Yes.
Yeah. Okay. So premature decision. Your hearing is set up and you did not avail. It means decision is not final decision. So at this time, no judicial review is available. But examination point of view, we have to go further. Because it's a 50 marks question, man. So you will be tested. Some people say, okay, we have to stop. What? Use your common sense, man. In one page, you're going to get 50 marks. In every page, you're going to get marks. Then jump into room number 2. Okay, room number 2. Sources. Ma'am, room number 2. Okay, computer guys, I need your eye contact. Computer guys, I need your eye contact. Hey, ma'am, what's your name?
Vaishali. Gerald
Dimu. Who is this guy? Kyoto, right to counsel. Okay. Okay, now I'm a judge. Who am I?
Judge.
I'm a judge here. So, okay, ma'am, you have done first room. The second room, admin body is right here. You are Kyoto. Okay, how, whatever, right? Okay, Dimu. So, how can I help you? In room number 2, what exactly you are looking for?
Right to counsel.
Oh, you are looking for right to counsel. Can you see under the act, under the subordinate legislation, under the policy and guideline? What is act? This question is act. What is subordinate legislation? This question is subordinate legislation. What is policy and guideline? This question is policy. Can you see? Must provide right to counsel. Can you see?
There is no provision with respect to whether dentists are entitled to be represented at any hearing. However, the rules provide...
No, can you see any? So, how you can answer?
So, there is no provision with respect to whether...
You can answer. There does not appear to be any specific provision for right to counsel in any enabling statute, subordinate legislation, policy and guideline. That's it. See? Can you see? Must provide. If silent mean they will not gonna provide, no provide. Right? Then common law entitlement. Number 4 step is SPPA, don't worry about it. Number 5th step is common law entitlement. In common law entitlement, this decision of the admin body is a legislative decision, or this decision of the Alberta Dentistry Board is a administrative decision. What do you think? Why?
Because it's for a specific.
Specific.
Yeah.
Hit to you. Specific. See first paragraph, last 2 line. $25,000 fine. Suspension for next 2 years. Okay. It means room number Okay. Then Charter of Rights applicable or Dominion of or
Charter of
Charter of
Rights.
Rights applicable. Room number 2 is done. Open room number 3. High procedure fairness, low procedure fairness, or medium procedure fairness. Nature of the decision. What